Yes! Hello, my beautiful friends. What an amazing day it is today. Will be even more amazing once we confirm we're coming through loud and clear and that the audio is alive and well and that the tubes have connected themselves all across the fruited plain of the interwebs, as you can see. We are on the road. We are here at Mama G's house. Thank you, Mama G, for hosting us, for allowing me to throw you out of your office. I love you. We have a jam-in show today, my friends. It's a beautiful Friday, and I'm very glad that you're here and with us. We got an early stream today, but we are jam-packed. And so we're calling a little bit of an audible right now because there is a hearing that should be starting in the Kilmar case. And so let me give you a quick preview on what's coming up, and then we'll zoom in on the details. But I hope your week is coming to a beautiful close because it is a beautiful Friday. We made it through another very busy week, and I'm glad that you're here with us. All right, let's see what's cooking today. We're going to be talking about this judge. Judge Zinnis, of course, is the judge who is handling the Kilmar case. Kilmar is this fella right here who was deported afuera out of our country. The Supreme Court came back down and issued a ruling on it. There was supposed to be a hearing this morning, and Trump asked for a delay on that, asked for an extension, and the judge came back and granted an extension, but only for like 3 or 4 hours. So it was supposed to be happening or have happened, and then it did not happen, and it should be happening in just an hour or so. So we're going to jump over this story and come back to it because we got a bunch of other stuff to get to. But we did have the Supreme Court ruling on this, so here was what that looked like. They came down, a lot of fake news about this, what this is, what this means. We're going to break it down, but we'll just bundle it up with the hearing because the Supreme Court sent it back down. And then there's a hearing, and then we'll see what the judge does based on that. So Supreme Court came back down, lots of nonsense on this, like the Supreme Court affirmed that he has to come home and all this stuff. No, it didn't. So we'll come back on that. We'll explain what's going on there, but some good reaction. We also, I think we'll start here today. We've got this other registration case that just came down. It is the Coalition for Humane Immigrant Rights. Okay, always do these stupid names. It's like the AIDS doctors or the Coalition to Save Grandmas Who Rescue Puppies. All of these, okay, whatever. So they sued Homeland, and this is on the change that Trump has made to make it mandatory for non-citizen alien residents who broke into our country to register and confirm who they are with the federal government. And they, of course, are not happy about that. They don't want anybody anywhere to register for anything. And they sued. So what happened is Judge Trevor McFadden, the judge that we talked about yesterday, he came down and said, guess what, you guys? You have no standing, your little stupid group. So get out of here. Come back when you have some actual standing, but they don't right now. So we'll talk about what that one means. We got Hakeem Jeffries is out. Oh gosh, doing his little hand movements there. I think he thinks he's Italian or something. But we also saw last night they passed the SAVE Act, and Trump has intimated what the administration policy is. So we could take a look at that as well. But we also had yesterday a very nice drop come down. The RussiaGate docs, the Crossfire Hurricane materials from the attempted rigged election in 2016. They screwed it up back then. They couldn't really rig it as hard as they wanted to. So they had to re-rig it in 2020, and their second attempt was better. But we still have questions about the first attempted rigging, and Crossfire Hurricane was where the FBI was colluding with the Hillary Clinton campaign to do just that, to try to rig an election. And they failed, obviously. But documents are now out. So we've got Sean Davis and our friends at Just the News who dropped this stuff out. So we'll go through and parse through some of these documents. There really was a ton that got dropped, a ton. This one's 100 pages. Here you can see. So we'll take a look at some of it. And of course, refer you to where you can go if you want to see the rest of it. It was like 7, I think, different binders that got dropped. So they scanned them all. And here's what they look like. But we do have some of the highlights. I've been parsing the interwebs and listening to the folks who've been doing deep dives on this for a while. And so they'll bring us some of the highlights and we'll get into them. We've also then got some Fanny Willis news because, oh my goodness, Fanny Willis's office is just abusing now even disabled people. This guy is being put through the ringer, okay? This dude is a paraplegic, okay? So meaning he cannot use his legs, and he's been arrested and charged with crimes by Fanny's office. Get this, okay? He's in a wheelchair, can't use his legs, arrested for kicking a door down. I'm not joking. Here's a whole thread on this from this attorney who's representing this guy. So we'll read through it. Fanny's just a disaster, saying that this dude kicked a door down. He can't even stand up, for crying out loud. So we'll go through that story and more. And I know some people might be confused about the thumbnail that's out there. You're saying, Papusa? The heck is that, Rob? What has gotten into this channel? What kind of slop is this now? Things are really getting a little bit weird here. But a Papusa, of course, is from El Salvador, and it is Kilmar's mama's business that was under attack from gangs because they were trying to take over the Papusa territory. So we'll be talking a lot about Papusas today. In fact, today is Papusa Friday. Enjoy your Papusas, baby. We're going to have a lot more Papusa expertise once Kilmar comes back to America. Thank you, Democrats, for inviting gangbangers back to our country. But we got some fun stuff to get to today, my friends. Thanks for being here and for supporting the work that we're doing. We're grateful to have you here. It's a real honor. So, all right. So I know what's happening here. I know it's all just going downhill. Sorry about that. All right. So let's take a look at what's happening out there in the lands. And every time we're on the road, you know, my technical switching and everything is a little bit botched. So thanks for understanding. But we got some good business to attend to, starting here. Mandatory alien registration now in effect. This order came down from Judge Trevor McFadden, a Trump appointee who we were not real happy with yesterday. But we're happy with this order because what he has found is that this group called Coalition for Humane Immigrant Rights, oh, what a bunch of really nice people, true heroes and civil servants for treating immigrants humanely. Okay, well, they sued Homeland Security and they said, hey, Trump's memo that says that if you're here illegally, you have to register or it's going to be a crime and you have to carry some form of identification with you or you're going to be in trouble. They sued to stop that. Well, guess what? Judge said, you got no standing. Here's what happened here. Says from the judge, he says, look, all right, background. Bunch of advocacy organization like the Humane Immigrant Rights Coalition, HIRC, we'll call it the HIRC, Humane Immigrant Rights Coalition, serving immigrant communities, bring a motion to stay, right? Trump issued a final rule, came out from Homeland. Thank you, Kristi Noem. So then they moved for a preliminary injunction and they are challenging a new rule. They say from Trump, he passed this, that previously unregistered aliens must comply with statutory registration requirements, saying that there is a form that was passed, fill out the form to get registered or else. They sued saying, you can't use the form's illegal. We love illegals in our country. So the so-called immigrant groups allege that the rule redirects previously unregistered aliens also to do the following: provide biographic and biometric info. So we're scanning your fingerprints, we're taking photos, we're doing all of the things. And you also have to carry proof of registration as well, since you're in our country illegally. But the judge says, guess what? They're suing on this. And unfortunately, the court cannot reach the merits of these allegations brought by the immigrants, saying they have failed to show that they even have a substantial likelihood of standing. Womp womp. As organizations, many of their harms are just too speculative. They have failed to show that a rule will erode their core mission, nor do they derive standing from their members. They have not shown that any individual member possesses a concrete harm that's cognizable by an Article 3 court. So that's a big victory there for Trump. And stuff like this, right? Even if Trump, you might say, well, how are they going to enforce this? They're just going to go around and stop people on the streets and say, are you illegal? Maybe. But in addition to that, stuff like this, I think, will cause people who are already on the fence of self-deporting to self-deport. And they can use the app to do that now. It was Uber into America, Uber invasion. Now it is Uber afuera. Uber afuera. It's a nice ride. Get yours today, courtesy of the federal government. The story behind this case begins in 1940, writes the judge, when Congress enacted the Smith Act, also known as the Alien Registration Act. Now, the act instructed aliens, except foreign officials, who were present in the United States, 14 years or older, who remain in the country for at least 30 days to register and to be fingerprinted at a local post office. And so remember that when they come out and they're like, Trump is forcing everybody to get on a list. What? They did in the 1940s. Talk to FDR about that, your lover boy. Now, upon registration, the alien was issued a form AR3 and the registration receipt that it can self-confirm, no immigration status or benefit, right? You're just registering to register. Thanks. Now, over the decades, the administrative state would dilute these statutory requirements by regulation. Okay, and this is the judge writing this, which is great. Trevor McFadden, we appreciate that language. Thank you. It is an administrative state, and they do dilute things down that are passed in order to secure the country. In 1944, the Immigration and Naturalization Service eliminated the division responsible for universal registration, and shifted registration from post offices to ports of entry and immigration offices. Interesting, right? So how many people are going to go to ports of entry versus a post office? You're already inland in America. You're not going to go to immigration. Post office is much more accessible than a port of entry because there's a lot more of them. And in the 1950s, INS suspended the use of that form. Instead, INS subbed in pre-existing immigration forms that were only available to aliens with legal immigration status, like Form I-151 for lawful permanent residents and Form I-94 for aliens with a record of lawful entry. Wow. So it just gets watered down, right? There's one form that is for unlawful, illegal people to use. And they just kind of use that form. If we have a separate form, then we kind of know who those people are. So why don't we just make them use the same form as someone who actually has legal status? That's our stupid administrative state. So through regulations, aliens who had entered the country illegally were effectively exempt from the statutory registration requirements since there was not a process by which they could register. Like the law was on the book, but there's no form. They just took the form away. Now, this is the judge writing, and regulatory dissonance continued with the passage of the Immigration and Nationality Act, 1952. Now, the statute supplanted the Smith Act, overrode that one, but it incorporated its same registration mandates, adopted that. Now, the statute requires that visa applicants go through the visa process, and for those not registered this way, the INA includes provisions for registration and fingerprinting of all aliens over the age of 14 who are at least here 30 days, and similarly makes their parents register. It also adds on to the Smith Act by adding a requirement saying aliens age 18 and older must carry registration at all times. And more, the INA makes it a crime, to willfully fail to register or to be fingerprinted, punishable by up to 6 months of prison. Now, the implementing regulations are a bit different. And so we talk about this a lot here, and this, I think, is going to be illustrative. So watch how this works. This is how our sneaky government works. So Congress will pass a statute. You'll see it codified in U.S. code. You see this USC, U.S. code, in these various sections. Now, Congress is not really good at implementing things. They're not really good at much of anything. So they write statutes, and they think, well, lawyers write these things, and they supposedly wordsmith them out and think them through. We learned that they don't. That's why we have a lot of litigation about them. But they pass a bill, law goes into effect, but then in order to implement the law, they have to create regulations. So you see these federal regulations. We refer to them here as the Code of Federal Regulations. You often see them cited as CFR, and the CFR is the implementation of the law. And then what happens there is in the regs, everything changes. They deviate away from the actual law, just like this. The implementation rules are different. Now, they first provide that only the available registration forms for aliens who were not lawful permanent residents was an I-94. Now, over the years, as Congress created additional forms, the INS added some of these forms as proxies for the registration document that was demanded by law. Okay, so they just change it like they're not following the law administratively via regs. Well, I mean, we can't. Congress wouldn't have known that we couldn't do it this way. So we have to do it this way. And that's pretty much in compliance with the law, isn't it, lawyer? lawyer, they send a memo. Yeah, it is in compliance because this. So it's like different from the law, sometimes 180 degrees different, but they say it's the same. But still, this means, says the judge, that the only aliens who registered are those with legal status. The regulations do not include a non-discretionary registration form for an alien who entered illegally. They don't want to count them. So then in 1960, the INS removed the carry requirement from the Code of Federal Regulations entirely. Now, this scheme persisted for decades. This is not democracy, by the way. Okay, this is not representation. The founding fathers were very unhappy when they did crap like this to them. They threw a bunch of tea into the ocean, and it was well-deserved because they were being exploited by supposedly their own government and their own people. That's exactly what's happening here. Okay, it's a scheme. It's not the law. They violated the law, but there's regulations and everybody does it. It goes on for decades. But in January 2025, that crap came to an end. President Trump switched course. He instructed Homeland, in coordination with Pam Bondi and Secretary of State Rubio, to immediately announce and publicize information about the legal obligation of all previously unregistered aliens to comply with the requirements of registration, and to ensure that all previously unregistered aliens in the United States do. And they're going to be treated as a civil and criminal enforcement priority. That is the executive order in compliance with the law. Now, last month, Homeland obeyed. Thank you, Christy. Homeland published an interim final rule, creating a new online general registration form, a form that should have existed for decades but didn't. It's called the G325R. Interesting, numbers, but okay. The interim final rule allows for a submitting of a form under statute, and plaintiffs argue this is a broadening of the requirement, and you can't do this. They say you created a new form. You can't do that. The law doesn't say you can do that. But before any of that could happen, before the rule could go into effect today, the date of this recording, on April 11, 2025, they sued to stop it from happening. Now, before that could happen, the date, they sued. They sought a stay of that date. There are a handful of these nonprofit organizations called Coalition for Humane Immigrant Rights, called the CHRLA, the CHRLAs, the United Farm Workers of America, and the Make the Road New York, and CASA. Yeah, all of these groups. Now, these organizations are member-based. They comprise many aliens, illegals, and citizens who belong to mixed status families. Now, they allege that the interim final rule, as they sue, was issued in violation of the APA. You can't do this. You can't make these changes. They say this is a new legislative rule. We need opportunity to know about it. It's arbitrary and capricious and more. But Trump responded. He says, look, no way. You guys are going to lose. By the way, you don't even have standing to sue here. So get out of court. And even if this court had jurisdiction, since they don't have standing, Judge Trevor, you can't hear this. The government insists, Trump, that the interim final rule is a procedural rule. So we're just making some procedural changes. We're not changing anything substantively. This has been in the book since the 1940s. The fact that every other moron president hasn't been able to enforce the law and execute the law, which is their constitutional duty, that's their problem. We're just procedurally changing things. You're not entitled to any notice at all. And the government says it's not arbitrary and capricious. It's a law. So the court, Judge Trevor, held motions earlier this week, and the motion is now ripe for a disposition. So we'll get a ruling. Judge says, look, a preliminary injunction is an extraordinary and drastic remedy. We've seen many of them here over the last several months. Now, the movement faces a high bar of success. So these illegal representatives got to prove their case. Now, they also have to show that they're going to suffer irreparable harm if this is not passed. We got to balance the equities, talk about public interest. But here's what happened. Now, they have not shown, these illegal groups have not shown that they are likely to succeed on the merits. They have failed to demonstrate that they have standing to bring this lawsuit. Standing is a bedrock constitutional requirement. Hello? It requires that a plaintiff possess a personal stake in the outcome, which helps to ensure that the court can decide specific rights in the case. Now, standing doctrine serves to protect the autonomy of those who are most directly affected so that they can challenge it. You got to actually have a case if you're coming to court. And it ensures that the framers have their concept of a limited court system vindicated. Citing John Roberts there. Now, to establish standing, a plaintiff must show that it has suffered or likely will suffer an actual injury and that the courts can do something about it. A couple ways they can do this. They can be an actual organizational plaintiff and have organizational standing. In other words, an organization can represent its members. So they say, let's start there. Well, if you want to demonstrate that you have suffered an injury, in fact, Coalition for Humane Immigrants, it must show that it's more than a frustration of its purpose that's happening. It's got to be something bigger. Mere hindrance to a nonprofit's mission, just because your mission, is not the abstract concern that gives you standing. Get out of here. Everybody would be suing everybody for anything. Instead, for an organization to have standing, it must have suffered a concrete and demonstrable injury to its activities. That is, Trump's conduct must have, quote, perceptively impaired the organization's ability to actually provide services, and they must have used its resources to counteract that harm. But it is not enough that these immigrant groups merely divert its resources in response to the actions. It's got to be more than just operational costs. Instead, they must show that they have had to expend resources in a manner that keeps it in alignment with its true purpose. The judge says, I'll give you an example of this. There was one organization in another case where they said that their mission was to guarantee safe, wholesome food. They sued, saying, well, this new system harms us, and we're going to have to increase this and do all of these other things. And they said, sorry, you lack standing. The new system is too abstract, like government changes things. You have to change as well. There was also PETA. Oh, gosh. I think I'll have some ribs tonight. Says, thankfully, PETA challenged the government's refusal to apply. The PETA refused to challenge the government's Animal Welfare Act. The government refused to apply the act. And they said, well, organizations whose activities have been impeded here have to have more. And this case looks less like the organizational impediment and more like the other case. Out of the plaintiffs, only Chirla claims organizational standing, but there's even a few issues with their claim. Now, they're suing the humane immigrant rights, very humane people, such heroes, say that they're highly speculative, their injuries that they're claiming. These are prospective fears about what might happen when the rule takes effect. They say, well, we expect, there you go, there's that language, we expect thousands of individuals are likely, hasn't happened, to reach out for assistance and advice with the new registration process. And we're going to have so many illegals calling us that we have to stop you because it's going to be a strain on our staff and budget. Like, America can't govern itself because illegal alien facilitation organizations are going to be busy with enforcement. So we can't govern our own country. It also expresses anxiety. That's their position, not what the judge held. It also expresses anxiety that the anticipated demand for legal advice and assistance may cause it to fail to meet certain grant conditions and thus face withheld disbursements, right? So we're not going to get our money either. But they say, come on. As the Supreme Court has said before in 1998 in Clinton case, Chirlas, the illegal groups, and their feared harms have yet to come to fruition, and they may never well manifest at all. It's just speculative. They rely on the choices of an unspecified volume of intervening third parties, the illegal aliens, who may or may not demand an indefinite amount of your resources. Yeah, they might just go back or just register. Just register the form, go about their day, or go home. They don't necessarily need to call you guys. When the existence of one or more essential elements of standing depends on the unfettered choices of independent actors that are not in front of the court, it's hard to establish standing there because it's too speculative. So Chirla might not be so taxed by a swell of inquiries that they lose funding. There are no numbers before the court, no evidence that they've given to us to suggest that, nor is there any evidence from grant providers that any termination looms. So without any facts, the court has just uncorroborated fear. But Article 3 requires more than just maybes. It demands actual or imminent harm, and they haven't done that here. And more, Chirla cannot demonstrate that the interim final rule has perceptively impaired its mission at all. There is certainly no claim that the government is blocking Chirla from claiming or doing its mission. They can do whatever they're doing before. Rather, they insist, they say, well, our community members are already calling our hotline And they already have questions about this. And now we're going to have to reallocate our times. So how dare these nonprofits actually have to do something and serve their constituency when our country enforces its laws that have been on the books for 60 years? But mere self-serving observations that an organization will have to increase the resources it's spending is not enough for standing. So are broad claims. They say, well, we've diverted our resources to deal with all of our aliens. When a nonprofit merely expands its operations to address increased demands from its communities, that's not called tampering. That's giving you more resources. That's giving you more demand. And as I've explained here before, the immigration industry right now is booming. Anybody in the space is crushing it. I've seen it most readily show up in law firms. But the law firms were dealing with people. I mean, just think about if this was your industry. Biden came in for 4 years. He created an entire market of about, I don't know, maybe 15 million new people who need immigration services like that with the snap of a ice cream cone. For 4 years, invasion, all of those people, think about 15 million new customers for you. Then Trump comes in, says, you're all leaving. Guess what? You got those same 15 million customers again on repeat business because they don't want to go. So now it's double business from both sides, and you have a market that's just massive. So all of these folks, right, have a whole new constituency of people to serve now. What are they complaining about? It's a government-created demand curve. Amazing. Says, arguably, these enhanced advocacy efforts are a fulfillment of the organization's mission. There you go. He's like, we created a bunch of new clients for you. In other words, the final rule has not impeded them. It's fueled them. They need your work. Indeed, the expenditures that Chirla has made have not kept it from pursuing its purpose. In fact, it's contributed to its purpose. Now they can get out there and just, scream, we're fighting for the humane treatment of illegals against Trump. AOC can go cry on a fence again. Chirla's own descriptions of its pursuits only undergird this conclusion, right? They're patting themselves on the back right now. They say, go on their website. Their mission says that we're ensuring immigrant communities are fully integrated with our society with full rights and access to resources. Get out. Get out. If they're illegals, we don't want them integrated into our communities. Okay, that's the point. Ridiculous. With full rights and access to our resources, just become a citizen. Hello. It's not that complicated. There's a whole process for it already. You don't need to exist. In furtherance of its mission, Chirla handles the full spectrum of needs of those primarily residing within low-income immigrant communities, yes. And one of Chirla's primary programs is a hotline where individuals, including members, clients, and community members, can call with questions. Great. Given Chirla's deep community ties and longstanding legal service programs, Chirla is often a first point of contact for individuals seeking information. Great. So the judge says, well, it would be odd if Chirla could assert that its core services have been impaired by using these very services that people want to use. Sure, the rule may have caused them to rearrange some labor and resources to meet the additional demand, but that's not a concrete injury. Just because shift in government policy demands shifts in internal operations. If that were the case, an organization could claim injury in fact nearly any time. Anytime there's a change in the law relevant to its mission, everyone can sue. This cannot be the law, says the judge, obviously. And indeed, it is not. Organizations only suffer concrete injury if a challenged government action has made their advocacy efforts more difficult than normal. And Chirla has not shown that here. So then we have to talk about associational standing. Can they sue on behalf of the illegals? 3 questions. Would its members otherwise have standing to sue in their own right? So could the illegals sue on their own? Second, the interest it seeks to protect are germane to its organization's purpose. And third, neither the claim asserted nor the relief requested requires the individuals in the lawsuit, right? So the organization can adequately represent them without them even being here. They say, nope, they stumble at the first step. They failed to show that any of their individual members would also independently have standing to challenge the rule also. It's a law. Associational standing also fails for 2 independent reasons. One, the only allegations of any harm to individuals are in the form of pseudo-anonymous hearsay. So little declarations from whomever, no one knows who they are. That's great. Anybody can make up fairy tales. That is, the organizations are describing the harms of their members while they use false names for them. Well, we can't identify them because they'll come under scrutiny and scorn from Americans like Rob. Says, the court has no sworn testimony from members themselves. Moreover, these pseudo-anonymous reports are contained in affidavits submitted by the organizations, which themselves are hearsay. So this means that all the court has to go on is hearsay within hearsay. Well, that's a racist thing to say. You don't trust them? While a preliminary injunction is customarily granted on the basis of other things, layered hearsay innately lacks credibility. Well done, Judge Trevor McFadden, as it only exacerbates the pre-existing veracity issues inherent in regular hearsay. Now, the problem becomes even more pronounced when it's under a pseudonym by illegals, leaving the court and the defense completely unable to verify anything. Isn't that convenient? The court is therefore very wary of this evidence. Yeah. More importantly, this nameless double hearsay is going towards the court's jurisdiction, and the court must abide by its unflagging obligation to police its own constitutional bounds. Now, asserting the authority of Article 3 based on nameless double hearsay strikes the court as an exercise in judicial arrogation, and the court declines to engage in such acts of personal aggrandizement. Wow. All right, Judge Trevor, I'm sorry I was so mean to you yesterday. I was upset. I was emotional, but I appreciate what you've done here. But even if the court were to credit the double hearsay, the plaintiffs other judges in D.C. should take a look at this, okay? He should put this, somebody should staple this to the refrigerator. But even if the court were to credit the double hearsay and believe it, the plaintiffs have failed to articulate a viable theory of associational standing anyways. Plaintiffs' primary conception of their members' injury is that they are directly regulated. That is, they insist that their members have suffering an injury in fact because they have to go fill out a form. They have to provide biometrics. They have to carry proof of registration, as the law says. They could face a harm because they could get arrested. But they have failed to show that the mere requirement to abide by the law, even if true that the accompanying regulation flouted procedural requirements when enacted, that constitutes a concrete injury. Otherwise, anybody would sue anytime they don't like a law. If you have a problem with a law, there's a remedy for that. You got to go engage in politics and convince enough people to change the law. That's the remedy. You don't get to sue the government. That's why we have voting. Plaintiffs' briefing and their oral argument had no claim that such a close relationship would allow a basis for a lawsuit, right? Saying like, they didn't make the argument that gives us the right to sue because we're unhappy with the law. They said that's not what they said exactly. But as made clear, you must identify a close historical or common law analog for your injury. Like, what is the injury? What is the tangible harm? It's got to be something like physical or monetary harm. Various intangible harms can also be concrete, but you got to give us something here. Now, they have not shown how merely being subject to a regulation without incurring any other injury or something is a harm. Like, it's the law. You got to do it. If you want to drive a car, you got to go get license and insurance and register your vehicle, right? You got to go do those things. Pretty basic stuff. They have not attempted to analyze, and if you're driving on a suspended license, that's a crime. They have not attempted to analogize their members' predicament to harms traditionally cognizable in an American court. So, like, there's no precedent for prior claims like this, nor does a historical analog so readily come to mind that an explanation would be unnecessary. They point to this other case to argue that subjection to new regulation requirements can be an injury, but that reliance is misplaced now. First, this case was decided before the sea change in TransUnion imparted upon the standing doctrine, so a lot changed after that, and thus the court doesn't have any occasion to consider this, whether this is sufficiently analogous. But also, the case is distinguishable. It's just not even the same. Now, it's true that courts have occasionally found standing when a plaintiff brings a challenge, but in those cases, the plaintiffs also had to show the law was hammering a constitutionally protected right? If the law goes against the Constitution, you can challenge the law, obviously, because your constitutional rights are supreme to that congressional statute. But if that is not the case, then the method of changing the law is by voting. Now, these people are not citizens, right? And they don't have a say in that occasion, which is why they're so upset and suing everywhere. But they don't have standing for it. Now, in other words, standing in the risk of prosecution cases requires that a plaintiff to show that he has been put in an intolerable choice, Okay, one or the other. You are either engaging in your constitutional rights or you're being penalized under the law. But that's not what's happening here. Saying the plaintiffs here have not shown that their members have been trapped in this paradox. If there are costly compliance measures, plaintiffs are mummed as to their amount. Well, how much is it going to cost to go get and fill out a form? Not much. Nor have plaintiffs shown that the final rule is penalizing constitutionally protected conduct. They say, well, it's going to force our members to reveal that they entered the United States illegally, and it could be a misdemeanor under 8 U.S. Code 1325. And by the way, that's another thing that you see a lot. I think I saw Abby Phillips on CNN saying, it's a civil offense. It's just a civil offense. It's not a crime. Because we always say, well, their response is they never committed a crime. We say, yeah, they did by breaking and entering into our country. They say, no, it's a civil offense. And I think they're conflating like overstaying a visa with illegally entering the country. 8 U.S. Code 1325, a federal criminal misdemeanor, entering the U.S. without inspection, illegal. According to plaintiffs, this admission is a violation of their Fifth Amendment rights against self-incrimination. Now, indeed, a major thrust of their motion relates to Fifth Amendment implications as well. But this line of attack fails factually and legally. First of all, factually, because plaintiffs have failed to demonstrate that any of their members would actually be subject to criminal prosecution based on their form, right? It's just a form. A charge for entry without inspection usually carries a statute of limitations of 5 years, which begins to run once they enter the United States. Then it expires, okay? So they race in here, and as long as they can stick around for 5 years, well, they don't have to worry about that federal charge. Nice. Nearly all of the plaintiff members have been residing in the U.S. for longer than 5 years. So you can't come in here and say, well, if they register now, then they'll be subjecting themselves to criminal prosecution, because they won't. The law's expired. Any plaintiffs conceded that their members do not have other crimes to report on as well. Thus, so for nearly all plaintiffs here, the Fifth Amendment right is not even implicated because they've been here illegally for more than 5 years. Incredible. Now, there is one possible exception. Her name is Ursula, fake name, obviously, but probably representative. A Churla member, Ursula, entered the U.S. without inspection in 2023. Are they picking like the most disgusting Disney characters that they could possibly find to give us a representation of who these people are? Entered the U.S. without inspection in 2023 as an unaccompanied minor when she was 17. All right, let's feel a little bit bad about that. But still, perhaps she could be subject to prosecution for an illegal entry misdemeanor, maybe, because she was a minor. Yet plaintiffs waffled on whether Ursula would be subject to criminal prosecution as an adult or as a juvenile. But does the government even prosecute juveniles for misdemeanor illegal reentry? Because the burden is on the plaintiffs to establish their standing, the court will not go digging into the intricacies of immigration law to deduce whether one member out of dozens could assert a potential infringement on her Fifth Amendment right. But even if Ursula could be prosecuted, her Fifth Amendment claim would fail as a matter of law. Now, a plaintiff can rest her standing on a violation of her right against self-incrimination in two cases. First, where the plaintiff remains silent, asserts the Fifth Amendment right, and then is subjected to some sanction or penalty. She clearly can assert a Fifth Amendment claim. Okay, I asserted my claim. I've been damaged as a result of asserting that claim, and now I can file a claim because my constitutional rights have been violated. And second, where a plaintiff has refrained from invoking the privilege, given an incriminating statement, and then seeks to bar the use of that statement later. A justiciable claim will surely exist, meaning she could do for that. Now, out of these two circumstances, she's not suffered a violation of her right. A violation of a constitutional right occurs only if one has been compelled to be a witness against himself in a criminal case. In other words, a Fifth Amendment self-incrimination claim is not ripe until a claim of the privilege is actually made. And no one is claiming that of her. No one's saying, come in and tell us about how you got here and tell us who brought you here and reveal more about your story and who else is involved. No one's saying anything like that. So she doesn't have to talk. Plaintiffs do not allege that any of their members have actually invoked their Fifth Amendment right and been rebuffed, saying you have to talk or else. Nor do plaintiffs even allege that an invocation of the right against self-incrimination on Form G325R would even lead to sanctions. They can't show that at all. At this point, any claim that the members make saying a risk of a violation of their right are just speculative and they're totally premature. And so the reason is apparent. The Fifth Amendment does not forbid the government from asking questions. They can ask questions. And it does not forbid the government from taking the answers. If you voluntarily give the answers, then you did that. Now, that leaves the assertions that form the new form chills their protected speech. They say, well, CASA and illegal members fear that the new registration process, which requires them to report their organization, will cause immigration authorities to target them based on their forms. But allegations of subjective chill are not adequate to confer standing. That's not enough. They must allege an imminent harm. Here, all they say is their members have engaged in self-censorship because they have a conjectural fear that they may be targeted. In other words, they say, well, it's their own subjective apprehension. If they're freaked out about this, they can go home. What they have not done is offered any evidence of a credible threat of prosecution for their speech, not for their speech. Nothing they're saying is going to lead to a penalty for them. It's the fact that they're here illegally. Under controlling law, that is what they had to do, is have some statute that made speech illegal. Government can ask questions. They can fill out their forms. In some, they're not going to win because they have no substantial likelihood of standing. And so their motion for a stay and preliminary injunction is accordingly denied. So ordered by Trevor McFadden, who we're happy with now. Again, all of a sudden, very difficult relationship to be in with us here. But that was a nice filing and absolutely right. You know, the people here for Coalition for Humane Immigrant Rights suing on behalf of people on issues that have not even occurred yet. And this law, as you hear constantly, Trump is being a dictator. Trump is invoking these ancient old laws. And it's always funny to me when they say, well, Trump overturned a 60-year-old law, or the Supreme Court did, or something like that. And you say, well, that's what you're doing right here, aren't you? You're kind of overturning this law via federal regulation. Not anymore. And so this goes into effect tonight, as you can see. We'll see if other lawsuits hit, but tonight was the deadline. And so that is now unleashed, and we'll see what happens in response to that. Now, Hakeem Jeffries came out, and he had a little bit of a statement here. And here's what he was saying about the border. And this was a curious one because here's Hakeem, and Hakeem Jeffries sounds like he's going to want to secure the border.
Republicans are proposing new spending for border security funding in this forthcoming budget bill. Is that something that your conference will support, that sort of security investment?
We have to look at the particulars. We believe that we need to secure the border.
What?
Make sure that it is safe and strong, that the rule of law, consistent with America as a country of a nation of laws, is fully and completely implemented at the border. We believe we have a broken immigration system and we need to fix it in a comprehensive and in a bipartisan way. And we also believe that we must always defend dreamers, farm workers, and law-abiding immigrant families and protect them from
what does that mean?
Overreach by the Trump administration. Those are the principles that we have consistently articulated publicly and privately to our Republican colleagues as it relates to finding some common ground on the immigration issue.
Wow. So that's Hakeem Jeffries. And he is speaking in a language that sounds like he's wanting to solve this border problem. Don't know what got into his tea. Might be the polls. So that was Hakeem Jeffries. Let's see what else we had. Oh, yes. The SAVE Act bill also got passed yesterday. So almost every single Democrat just voted against the bill to require proof of U.S. citizenship before registering to vote in federal elections. So they just want more and more of this. Look at that. 208 Democrats voted against it because they love the illegals. They don't want people registering, but the SAVE Act is going to change that, saying this administration from Trump, he'll sign it as long as the Senate gets it to his desk. The SAVE Act, Safeguard American Voter Eligibility Act. The bill would enforce a principle long enshrined in our laws, writes the Trump administration. Only citizens may vote. While federal law explicitly prohibits foreign nationals from registering to vote or voting in federal elections, loopholes and deficiencies in the National Voting Registration Act have allowed non-citizens to illegally register to vote and hindered states' ability to stop it. We covered this a lot in both last elections. Though amendments to the NVRA and through them, the SAVE Act would end the lawlessness by requiring states to obtain proof of U.S. citizenship before registering an individual to vote in federal elections, while establishing safeguards to ensure every citizen is able to register. The bill would also require states to regularly remove non-citizens from their existing voter rolls and provide the tools necessary to do so. Even more fundamental than enforcement of federal law, the bill will increase the public's confidence in the fairness of our elections and the validity of their results. If H.R. 22 is presented to Trump in the current form, his advisors would recommend that he sign it into law, and we hope he does. So it's off to the Senate. Hopefully they get it done and they get it on his desk. All right, so good update on the registration stuff. So let's see what time. Let's do a time check. We're asking ourselves whether the hearing is underway, and I think it was scheduled for a 1:30 hearing, so I think we got a little bit more time left. So let's talk about these RussiaGate docs and see what's cooking over here, and that will buy us a little bit more time. So it's a beautiful day, my friends. Thanks for being here. Let's see where we're at now. We've got some RussiaGate documents that have been released, and let's start over here with this document, because this is what we think might be some juicy stuff. Crossfire Hurricane RussiaGate documents now released. We've got a bunch of files we're going to go through today. You can see this one is 100 pages, and it came out on April 9th. It's one of 7 binders that was dropped and released. We'll take a look at the highlights, and it is hundreds, if not thousands of pages of documents, but they came from our friends over at Just the News, John Solomon, and we got them from the Federalist, our friend Sean Davis. And he says, look, we have got the RussiaGate binder. And if you forget about RussiaGate, back during the first election, there was this whole allegation that Trump was colluding with the Russians back in 2016. Hillary Clinton was working with it. There were Democrat lawyers like Mark Elias, we talk a lot about here, like Michael Sussman, other people who were facilitating with Fusion GPS, Christopher Steele, the Trump PP dossier, all of that stuff. Okay, all a setup, all fake. The FBI was trying to get Trump from the very beginning, spied on his campaign, set him up, all the things. Now we're getting our hands on documents that they buried. So Sean Davis says, look, we got the RussiaGate binder. It consists of 7 separate files totaling hundreds of pages. In the interest of full transparency, we're making the documents available for everybody, and I've opened all of them up now. But there's a lot inside. And so for some good analysis, let me bring in John Solomon, who's been covering this story for quite some time. And his news entity also got the documents and published them. And this is Svetlana Lokova, who said that Solomon says that perhaps the most important document in this Crossfire Hurricane release is that this guy called Stephen Halper lied to the FBI about General Flynn and Svetlana. Okay, so she's a party to this. They knew it was a lie, but they continued to use Halper for another 4 years. And then Halper was facilitating the lies. Like, and they were paying this dude to write up these stories, like $1 million bucks. So it's all coming out now. Here's what John Solomon said. And John Solomon, of course, has been a key investigator on this case for a long time. And there's many people who were on this case well before we even started our show. And so congrats to them and their vindication, having fought for these files for coming up on a decade.
The fight for them, Donald Trump came back into office and he released them a second time. And today they got to Congress, and then they ended up in the hands of Just the News. And in just an hour, you're going to see our first story. I'm going to give you a timetable, 7 p.m. Our first story is going to come out on justthenews.com. At 8 p.m., we're going to give all the documents one by one and post them onto the website, so you have a sort of Wikimedia wiki to go look through the documents yourself.
We're going to look at them.
Some good stories. Let us know at Just the News, and we'll go pursue them. We're going to tell you about one right now, perhaps the most important thing in the documents that we found early on. One of the 2 informants that were used by the FBI to spy or to snitch on Donald Trump and his campaign was named Stephen Halper. He's not the most famous. Christopher Steele, the guy that wrote the dossier, he's the most famous. But Stephen Halper was used quite a bit by the FBI. In fact, he was used for 3 decades by the FBI, and it turns out Snitching is a pretty lucrative profession. He got paid nearly $1.2 million
Dang, son,
to be a confidential human source from the early 1990s to 2017. The last of those payments, $70,000 for his work snitching on the Trump campaign and the Crossfire Hurricane early investigation.
Spying on Trump.
What are we going to tell you about it? It turns out that he got that money and he kept being used by the FBI and he kept being validated as reliable, even though the FBI detected he had given them an inaccurate, false, or disprovable story. What is it? He's the guy that told the FBI that Mike Flynn, soon to be Donald Trump's national security advisor in the fall of 2016, back in 2014, had left a conference, an overseas conference, while he was a three-star general and the head of the Defense Intelligence Agency, alone with a Russian woman. Now, the FBI determined that was implausible and inaccurate. In fact, President Mike Flynn's own security detail would never have left him alone. He was a three-star general and the head of the intelligence agency. He was always guarded by people. They determined it was unreliable, not true, inaccurate, not plausible. But guess what? They kept using him to keep digging further and further into people like George Papadopoulos and Carter Page and others. We're going to get all this up for you to read. We want your own eyes on it. You look at it, you see it at justthenews.com, 7 p.m. Once we get off the show, the first story will be up. There'll be all the documents listed in chronological order or by titles. You can go do your own sleuthing tonight. We give you a homework assignment. All right.
There's a lot of documents out there. So let's go through some of them. And there were some amazing people who were digging through this last night. Here's some stuff that I found. And this one came over from Walter Kurt. He says, breaking, the FBI paid Christopher Steele as a CHS and directed him to investigate specific buckets of information on Trump, right? So here's some of the documents. Spying on Trump's campaign, paying someone to do it, FBI payment request. And this is redacted, but its source ID is Steele. Case agent name, Michael J. Gaeta. International Operations, says, here's the payment request form from Michael Gaeta from Steele. $74,000. Wow. On 10/30/2013 was when he was opened. Okay, so that's not the payment date because you're saying, well, that's before Trump came in. So he was opened and reopened on. And this payment came out. Look at that. Yeah, this invoice date. 5/4/2016. Who was running for president at that time? Oh yeah, President Trump. So look at that, 74 grand total. He's getting paid on that. That was just one segment. We also saw our friend Amuse posted this. Here's a photograph of the dude. So Amuse posted this on X. Be sure you're following him. Says the FBI paid longtime informant Stephen A. Halper $1.2 million, even though it knew the intel leak was fake. Halper worked closely with the CIA, gave them fake intel to justify Crossfire Hurricane. And that's what the dude looks like. Here's more from Walter. Remember McGonigal, Charles McGonigal, also was working on this. Said Hillary Clinton was working directly with disgraced FBI agent Charles McGonigal in 2014. Now, McGonigal was informing Clinton of damaging information so that she could, quote, take the appropriate protection. McGonigal was the architect of Crossfire Hurricane. He was the head of counterintelligence. This proves that Clinton was working with the FBI prior to even opening up the investigation into Trump, right? And we know that this was a thing because we covered the Michael Sussman trial here at length, and we listened to Mark Elias come on the stand and suddenly forget everything about everything that happened during that time. I don't recall. A dude who's clearly intelligent suddenly forgot everything. That might be a problem for Michael Sussman in the middle of a trial. Now, Michael Sussman was acquitted, but we saw what the game was. He went to the FBI. He said, I've got this story. The story's going to break from the media any minute, and it's going to show this. And so you got to get ahead of it to investigate it, because if once it breaks, everyone's going to scatter. So FBI, go. It was a fake Russia collusion hoax from Christopher Steele. Fake to the FBI by a lawyer. Should have known it was fake. Probably did know it was fake. Jury didn't think so, but took it to the FBI, simultaneously went over to the media and said, the FBI is investigating Trump for Russia collusion. They said they are. And then Jake Sullivan came out and posted a story, right? They're playing both sides. Total scam. And they obviously have been doing it for a while. Now, all of these law firms like Perkins Coie and many others are all getting hammered by Trump, and they're crying foul all of a sudden. How dare you do this to us? You guys played this game. Now you have to reap the consequences. So here, this one was CC to Charles F. McGonigal, saying to document defensive briefing to David E. Kendall and his associate Catherine Turner, both of Williams and Conley LLP, personal attorneys to Hillary Clinton. Kendall and Turner were advised, the FBI, and was providing them with this briefing for awareness. And so Ms. Clinton could take the appropriate action to protect herself. They were also told the FBI was seeking their assistance to identify the appropriate recipients of the brief, if any. Yeah, and it's interesting. I'm not sure exactly what this would be relating to, but this is a 2015 date. And so I think Hillary Clinton was far out of the Secretary of State position at that time, right? Hadn't she left? Wasn't she during the first part of Obama? Anyways, so why would she be needing protection from the FBI? Don't know. But here was another one from Fool Nelson, and shout out to Fool Nelson, who's been digging on this one. Recommended follow Fool_Nelson on X as well, doing some great digging. Says Pienka spying on Trump during his defensive briefing. This is sick. So here's another document, right? So they bring this dude in, this Pienka dude. He's sitting around like inside the Trump administration. They bring him in as part of the administration, let's say. And he's reporting back, spying on Trump, right? They're spying inside. This is Americans spying on other Americans because they want to beat their candidate. It's sick. It's really surprising that they're not in jail. But title, document brief to the Republican candidate for U.S. president. Says this is National Intelligence Manager for Iran, name withheld due to cover concerns. Says during their ODNI briefs, Ryder actively listened for topics or questions about Russian Federation. Okay, so this dude comes in and he's spying. During Mulligan's brief, he stated the U.S. is the world leader in counterterrorism. Trump then asked, Russia too? During a discussion regarding nuclear testing, Russia and China were brought up as cheating on the nuclear test ban treaty. Trump asked, who's worse? Redacted. Trump and Christie turned toward each other, and Christie commented, I'm shocked. Now, due to time constraints, not all ODNI briefers presented their material. At 1750, the briefing ended to allow the candidate to meet his plane at 1900. Trump, Christie, and Flynn shook hands with all presenters and exited the skiff at approximately 1751. Trump's being spied on right here, and they're writing reports about it. During the campaign, August 30th, 2016, writing reports from spies within the campaign. It's insane. Democrats, government, doing it. Sick people. Here was another one from Fool Nelson. Said, I'm not sure why this quarterly report exists in the 2016 June for Halper before the opening of Crossfire Hurricane, but we're also missing the first page of it. He's noticing. Okay, page 204 is in there. Source 2 was closed by the FBI in 2011 for aggressiveness towards handling agents. And he says, I wasn't compensated enough. However, Source 2 was reopened 2 months later by Case Agent 1. And Case Agent 1 handled it and then conducted human source validations on Source 2 in these years. All right, so lots of documents. And here was one final post over from Hans Monkey, another great follow, and bigger on X. Says, we knew at least 3 of Steele's bogus dossier reports, 132, 137, and 139, had been hidden for the past 8 years. But now we have 132. It's such a total nothing burger. It's just Steele making things up. You have to wonder why they bothered to keep it secret at all. Company intelligence report. So this is from Christopher Steele, apparently. Says, Russia, Putin now regrets U.S. presidential election influence operation. Okay, all made up. Top-level Russian intelligence figure claims Putin now regrets operation to interfere in presidential election. Putin thought U.S. political system, similar to Russia one, corrupt, but now considers this was a big error. Detail. Speaking to a colleague in mid-October 2016, a former top-level Russian intelligence officer and current Kremlin advisor claimed Putin now regretted Moscow's interference to back Trump. The officer said it backfired. Continuing on this theme, the former top national intelligence officer opined that Putin's mistake had thought that it was our system was corrupt. It is. The Trump influence, he's not wrong. The Trump influence operation had been one of his biggest mistakes. Okay, so more just garbage from Christopher Steele. What is that? Yeah. Former top-level former Russian intelligence officer was not explicit about from whom he had obtained the above information. No idea. No idea where it came from. He implied it came from Putin or someone himself very close to him in the Kremlin. FBI's like, oh, this is shocking. Tell everybody. We got new intelligence that just came in. It's like this just, you could type that up like on a Word document on the toilet. It's ridiculous. All right, so let's take a look at the actual documents that are here, just so we can get a taste. Unclassified for official use only. Crossfire Hurricane, redacted binder. Here's tab number 2. Opens with this. On Monday, September 18, 2017, and Tuesday, the 19th, Christopher Steele from Orbis Business Intelligence was interviewed by the Grosvenor Hotel by FBI agents. The following information was provided by Steele over the course of a 2-day interview. Now, on September 18th, in the initial part of the interview, Steele was accompanied by another executive called Burroughs. After about 45 to 60 minutes, Burroughs departed. Steele sat there for the remainder of the interview. Now, he explained, Burroughs said, he opened the interview. Wow, Burroughs, he's sitting with FBI agents. He says, I think we got some loose business ends with you punks at the FBI. Burroughs says, me and Steele are pretty upset about how the relationship with you guys concluded because of the time and effort that had been taken to get information to you. We work our butts off for you guys. This is September 18, 2017. Okay, so Trump is now in office, and now they're furious. Burroughs said, we had a contract with so-and-so, and that maybe the contract had been put together with Steele serving as the face of Orbis, but there was a contractual relationship. So you may have had a deal with Steele, but you were dealing with me. Now, Steele and Burroughs apologized for going to the press back in the fall of 16. Sorry we had to go there. But Steele explained that as the election went on, they, as the company, we were riding 2 horses here, okay? We had to serve our clients and we had to serve the FBI. And after FBI Director James Comey's reopening of the Hillary investigation, we had to pick one horse to ride with, okay? And choose the business and client relationship over the relationship with the FBI. So they followed what the client wanted, and we spoke to the press. So Hillary wanted us to go talk to the media, so we did. Now, Steele and Burroughs described the overall situation as being one where it was your FBI fault, our fault. Steele said that it was not about the money owed, but Burroughs remarked that Steele might not be that concerned about the money, but Burroughs was. I want my money. Now, they were confused over this agent, whether he represented the FBI or the Office of Special Counsel. Burroughs said, I know Robert Mueller from my former career. So we want to make sure that you're talking to the special counsel. Okay, so it's incredible. So the same people who tried to set Trump up are now working and know Robert Mueller, the guy who was brought in here to create a fake investigation on this. It's a joke. The guy, Burroughs, knows Mueller. Or what? Steele and Burroughs indicated frustration by the inclusion of their company's reporting in the Russian interference scam. Steele and Burroughs felt that they should have had advance warning. We didn't know our name was going to be in there. This has a massive impact on our lives. We worked our whole company here to build up a reputation and have some credibility here, and you just publish out in there? Burroughs wanted to know how the U.S. and blank had worked all this out and wanted to know if the blank government was told that the information was going to be in the ICA. What government is that? UK? Wanted to know how the UK and the blank governments, what is that in there? FGI? Foreign government something, maybe? What government is it? UK? Steele and the United Kingdom, did they write that out? They didn't write out US. Steele and Burroughs, Israel. Steele and Burroughs described, what did I say, Israel? Steele and Burroughs described President Trump as their main opponent and indicated that they were fearful about how Trump's presidency negatively impacted the historical UK-US alliance and the US-UK special relationship. Is it UK-EU? I don't know. Steele and the Glenn Simpson and Fusion GPS was knowledgeable that Steele was sharing reports. Steele explained that in the run-up to the election, he gave material to Bruce Orr and were pushing Orr to do something about the report. So they're all panicked. Steele said that he had been unsure as to whom blank he could provide the election-related reports. He decided going against the primary and more. All right, so this goes on. Now, this goes on for about 100 pages on this one, so obviously we're not going to read the rest of it, but there's some juicy bits, I'm sure, inside. but I wanted to just give us a taste for that. And this was largely an operation between the US and the UK, allegedly, but I happen to think it was just internal, and that the UK government was just an excuse, essentially, like a fake because, to make it look like that we weren't actually doing this stuff internally. Now, that was binder 1. Here is what binder 2 looks like. This is another 100 pages. So binder 2, you see admonishments here on Steele. Looks like he's signing a form to act as a confidential human source, so some paperwork to bring him aboard. This was provided verbally. Somebody said, human validation report, CHS validation report, background. Steele's a foreign national, currently employed at his or her own business. Came to the attention of the FBI, and they're going to say he's credible. The guy was not credible. The guy made up fake stuff, and now he's mad about it. We saw that in the opening binder. So it looks like this is just their internal assessment about, oh, here's another summary from Steele, looks like. So his little fake book reports, wrote that one in June. Fake garbage. All right. So that's binder 2. Let's look at binder number 3, see what's inside this one. Here, another CHS contact report, probably some good stuff in here, but this one is another 100 pages. CHS was provided with an eagle to wear during the meeting with the target. This one looks like it's Halper meeting with the target. He's wearing a wire. That's great. So here's one. Looks like another event, another one from Halper. Another questionnaire for Halper. Is CHS a criminal or national security? Yes. Long-term stuff. So, okay, more documents here. Lots of paperwork. So let me show you the other sections. And then, of course, if you want to look these up, I'd refer you over to Just the News or to the Federalist. But here's another binder. This looks like just text messages or communication exchanges that were captured on government phones. So it's about 100 pages of that. Oof, a lot. So a lot of materials in there. You know, I wonder if AI would give us some good details on this if somebody puts them in. Here's another one. More phone records. This looks like less interesting. Looks like some call logs, text logs. Lots of redactions here. I thought that we weren't supposed to have many redactions on these, but a lot of redactions on that one. Here is binder 6. More logs, maybe emails, undercover messages back and forth. And then here is the final one. So binder number 7 looks like it is 84 pages. And it's another report. It says on Saturday, May 20th, 2017, acting Deputy Attorney General or Deputy AG Rod Rosenstein called my cell phone. He asked if I was working, if I could meet him at Robert Mueller's office. I indicated I was not working and that I was busy. I can meet you on Sunday, though. On Sunday, I then met with them, opened the meeting, thanking me for my work. He stated that he did not believe I had conflicts with the Russia investigation. Despite this, he then stated that he thought I should consider recusing myself from the investigation. So is this with maybe Sessions? Let's see what this one was. Lisa Page wrote that. We left the meeting at 9:10. Everyone else remained in the room with DAG. That's interesting. So Lisa Page, of course, was the other half of the FBI lover scandal. So these are the documents that have been released, and there's going to be a lot of sleuthing to go on. So 7 pages. This one is 700. This is 84 pages. And so about 784 pages of Crossfire Hurricane materials have been released. And so the full files will be over with John Solomon at Just the News and our friends at the Federalist, Sean Davis. Thank you to those 2 organizations and those gentlemen for releasing the docs and making them public so we could all see them. The sleuthing will continue and the good stuff will cover. All right, so we got that story. Now, I think we should be getting close to hearing time on the Kilmar case, which means, let me just double check that to see if there's any latest on that. Let's check out who's covering this probably today. Margot says, let's see who's over there. All right, so we're going to cover it, and then we'll see if the hearing happens and if people are covering it. Yes. Okay, Kyle Chaney looks like he's covering it. Okay, cool. There should be a hearing today. All right, so we're gonna get into this story and see where we go. See what happens by the time we get there. We're starting with the Supreme Court. Start with the Supreme Court. We'll start here, and then we'll see what happens. All right, so let's get to it. The Supreme Court has spoken in the Kilmar case. The deportee, who the judge ordered to be returned home, got a decision, but it's not very clear exactly what we're going to get in totality, because this is going back down to the lower level judge, and then she's going to have to abide by this strange decision from the court. So we're going to go through the decision itself from SCOTUS to try to interpret what's happening here, because there's a lot of fake news on this saying SCOTUS came out 9-0 and ordered him to be flown back home and given a mansion. That's not what they said at all. But we also had a bunch of new filings that came in the immediate aftermath. So as soon as SCOTUS hit, Kilmar's lawyers went hog wild, started filing stuff. Trump's lawyers started filing stuff. And then we're scheduled for a hearing today. We'll come back on that. But here is what SCOTUS said after hours, late at night, in the case involving Kilmar, Armando Abrego Garcia. And we remember this person was alleged to have been a gang member and had previously missed his court dates, was already adjudicated to be non-bondable because judges found that he was not credible and a potential danger to the community. So they held him in custody. He then, of course, appealed that and lost. So he's had plenty of due process. He's not in the country legally. He doesn't have a visa, not a permanent resident, only was not supposed to be removed to El Salvador. That's where he got removed to, but he's presumably still there. So what the Supreme Court said is this. On March 14th, the United States removed Kilmar, an alleged gang member, from the United States. He's currently held in El Salvador at CCOT. Now, the United States acknowledges that he was subject to a withholding order forbidding his removal to El Salvador, only that, and that the removal to El Salvador was therefore illegal. Now, the United States represents that the removal was just an administrative error. The United States alleges, however, that Abrego has been found to be a member of a gang called MS-13, a designated foreign terrorist organization, and that his return to the U.S. would pose a threat to the public. Now, Abrego says, I'm not a member of MS-13, and that he's lived safely in the U.S. with his family for a decade and has never been charged with a crime, which might be true. Never been charged with a crime, but by virtue of entering the country illegally without registering, that's a crime. Now, on Friday, April 4th, the United States District Court for the District of Maryland, Judge Zinnes, and we remember Judge Zinnes as this woman here, who was appointed by Barack Obama. She is a political appointee. She had no prior judicial experience before becoming a judge. She did act as a law clerk for a judge way before this career. She was a public defender, and then she went into private practice where she was suing cops and would sue them for damages or injuries to people, make a ton of money off those civil claims, and got rich. So then, of course, she got appointed by Barack Obama. And as we know, Kilmar is this person, and we've seen a photograph of him here and seen the whole story of him, courtesy of Will Chamberlain, and gave us the details on his immigration documents. But that's the judge who was ruling on the order to direct the government through Trump to facilitate and effectuate the return of Abrego. And remember, she said he needs to be back here by midnight, 11:59 p.m. on Monday, April 7th, or else. Now, on the morning of April 7th, the United States filed this application to the Supreme Court saying, we can't get this guy back by Monday at midnight. It's not going to happen. Chief Justice John Roberts issued an administrative stay, and then the full court heard the application. Now, the application is granted in part and denied in part, subject to the direction of this order. Writing from the Supreme Court saying, due to the administrative stay issued by Chief Justice John Roberts, which we read through earlier this week, to that extent, the government's deadline has now passed. So to that extent, the government's emergency application is effectively granted, right? The deadline is no longer effective, so they won that. But the rest of the district court's order remains in effect. but it requires clarification on remand because the judge's order is terrible. And this is the court asking or basically giving the lower level judge an opportunity to save face, saying your order was very bad and you can fix this if you'd like, but we need you to do that. Saying the order properly requires the government to facilitate Abrego Garcia's release from custody, and the word facilitate is appropriate, and to ensure that his case, facilitate the release from El Salvador, and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador, right? So what does that mean specifically? The intended scope of the term effectuate, though, so the judge said facilitate, but effectuate is different. That, however, is unclear and may exceed the district court's authority. Now, the district court should clarify its directive with due regard for the deference owed to the executive branch in the conduct of foreign affairs. And so for its part, the government should be prepared to share what it can concerning the steps it has taken and the prospect of further steps. So very wishy-washy, saying the order heretofore entered by the Chief Justice is vacated. It is vacated. So what we have to do is send this back down to the court, and the district judge will have to figure out what to do about it, saying, here's the statement of the dissenting judges, saying the United States government arrested Kilmar and flew him, sorry about the dogs, and flew him to a terrorism, hang on one second. The United States government arrested Kilmar Armando Abrego, says the dissent, and flew him to terrorism confinement center. This is the dissent, saying to this day, the government has cited no basis in law for his warrantless arrest. Yes, they have. He's not here lawfully. And his removal to El Salvador. Trump issued a proclamation. The situation changed, and he's not legal. He's not here lawfully. They say the government remains bound by an immigration judge's order expressly prohibiting the removal to El Salvador because he faced a clear probability of the future prosecution there, and demonstrated that El Salvador authorities instead of hastening to correct its egregious error, the government dismissed it as an oversight. The government now requests an order from this court permitting it to leave Abrego, a husband and father with no criminal record, in a Salvadorian prison. The only argument the government offers in support of its request that the United States cannot grant a relief once a deportee crosses the border is just plain wrong. And so the dissent goes on. And of course, we now have questions about what to do. And we're waiting for the animals to calm down. They're as angry as we are. Quite frankly, they can't believe this crap is happening. You know, I don't blame them. They hate this corruption in America. They're letting us all hear about it. All right, so let's take a look at what happened now. Immediately after the Supreme Court came back down with their decision, and they sent this back down, and they said, please clarify what you mean. What does facilitate mean? What does effectuate mean? Soon as that happened, Abrego's lawyers sent this into the court. They said, we write on behalf of Abrego. The Supreme Court today ruled that they must facilitate and effectuate the return, and that remains in effect, but that the term effectuate may require some clarification. Now, given the grave danger to Abrego Garcia's life, we request the court bring him back immediately to address the government's compliance and to address the compliance with this court order, saying, bring this person back. All right. So Jonathan Cooper, writing for gangbangers like Abrego, are demanding that he be returned. So in addition to that, we got now a new order from the judge. So Judge Zinnes came out. Soon as the Supreme Court sent this back down to her court, she came out and wrote the following. So a lot of stuff happened last night, back to back. Says the Supreme Court, this is the judge writing, Judge Zinnes, saying the Supreme Court's decision in Nome versus Abrego Garcia affirmed this court's order and directed that on remand, this court clarify its use of the term effectuate. What does effectuate mean? According proper deference to the executive branch in its conduct of its foreign affairs. So the judge says, so to this end, the court hereby amends the order to direct that defendants take all available steps to facilitate the return of Abrego as soon as possible. Okay, we direct you now to take all available steps to facilitate, which doesn't mean that you are ordered to effectuate. It's just to facilitate. Okay? So in other words, the judge can't force them to do anything. It can just encourage them to facilitate it. Now, as the Supreme Court made clear, said the judge, the government should also be prepared to share with what comes next and your further next steps. And so accordingly, the court directs Trump to file by no later than 9:30 a.m. today. This is already expired, by the way. A supplemental declaration from an individual with personal knowledge addressing the following: the current physical location and custody status of Abrego, what steps, if any, Trump has taken to facilitate his immediate return, what additional steps Trump will take to facilitate his return, and to the extent the defendants believe any portion of their submission must be filed under seal, follow the rules. Now, we also will have a hearing today, 1:00 p.m., which we're waiting to kick off. Signed by Paula Zinnis. Okay, so judges came back down, said, what does effectuate mean? The judge basically deleted effectuate, just said take all available steps to facilitate the return, is what she wrote. And she said to the United States as soon as possible. Now, I don't think the Supreme Court necessarily said that, but let's go back and double check that, because here is what they said from the Supreme Court specifically. Effectuate the return, to the United States. On the morning of this, we vacated the application. To that extent, the government's emergency application is no longer effect, the deadline, but the rest of it is in effect. Okay, so the rest of it is in effect. So she's going to require him to come back here. And it sounds like that's what the Supreme Court is requiring as well. With due regard, for its part, the government should be prepared to say what they're doing with him. Interesting. Okay, so now she said that, right? She posted, to the extent that they believe they can file under seal, file under seal. Otherwise, get this dude back to America. So then Trump responded. Now, Trump sent this one right this morning, right before the hearing. Said, Trump now requests that the court modify its amended injunction. Please give us a modification so we can have a reasonable period of time to review this stuff. The Supreme Court entered its order partially granting and partially denying the stay after business hours last night, saying the initial deadline contained in this injunction, which requires Trump to provide the court with a plan for a diplomatic engagement 30 minutes into the business day after the Supreme Court ruled on this, is ridiculous. It's inconsistent. The Supreme Court gave them a clear instruction to clarify your directive. Hey, court, you are supposed to have due regard for the deference owed to the executive branch. Due regard. Now, that deference requires that the executive be given a meaningful opportunity to review the Supreme Court's decision before it is ordered to report what steps it will take in response to that decision. It would also be impracticable for Trump to comply with the court's deadline only a few hours after the Supreme Court issued an order. Like, we can't do it. So the amended injunction further is inconsistent with their directives to be in compliance with the deadline in the challenged order is no longer effective. Okay, so you need to give us more time. So Trump's DOJ asked for this, says, please modify your order until 5 p.m. on Tuesday, April 15th, 2025. So that's like a week or about 4 days from now. And to reschedule any hearings on the matter until Wednesday, April 16th. Now, the judge didn't bite that at all. Okay, so they want until next week on Tuesday. The judge came out and said, how about no? How about you get until 11:30 today? They say the defendants asked this court to extend the deadline to respond to its order, arguing that Trump needs several days to meaningfully review the decision that was issued at 7 p.m. last night. Get that under red. I don't know what that was. Says it is impracticable for defendants to comply with this order. They say this supports an extension. But the judge says no. First, the act of sending Abrego was wholly illegal from the moment it happened, and you've known about it from the beginning. Now, as the Supreme Court says, It was therefore illegal. They even acknowledged you did this illegally. Now, second, Trump's suggestion that they need time to meaningfully review a 4-page order that reaffirms this basic principle blinks at reality. Okay, can you explain that? And third, Trump misconstrues the Supreme Court's order, stating that the original deadline is no longer effective, as somehow suggesting that the court's amended order requiring prompt attention to this matter is inconsistent. Nothing could be further from the truth. Now, as the Supreme Court plainly stated, the government should be prepared to share what it can concerning the steps it has taken and the prospects of further steps, all against the backdrop of this court's needing to ensure the government lives up to its obligations to follow the law. And so accordingly, the court grants in part the request and will extend the filing deadline until 11:30 a.m. today. 11:30. Amazing. Thanks for all that additional time, Judge. Now, the hearing date and the time will remain unchanged, signed by Paula Zinnis, Obama judge. So gave them basically no time at all to respond. Now, Trump's people asked for the extension of time, and we're doing a refresh right here. Let's see what this document is. That just dropped. Okay, new document just dropped as we're sitting here. This one just came in as well. Let's swap over to this screen. Says here, Trump responded to a new amended order. Okay, so the judge just issued that new order and said you have to respond by 11:30 and you got to be here for the hearing. Trump just said this. Sorry, Judge. We asked for more time. We are unable to provide the information requested by the court on the impracticable deadline set by the court hours after the Supreme Court issued its order. So you're not getting it. Sorry. The Supreme Court's order directs the court to clarify its directive with due regard for the deference owed to us. You're not owing us any deference. This court has not yet clarified what it even means to facilitate or to effectuate the return as it relates to this case. The plaintiff is in the custody of a foreign sovereign. He's their citizen, not ours. Trump requests and requires the opportunity to brief that issue prior to being subject to any compliance deadlines. So we need more than your little order. Needless to say, Trump was under no obligation to take action under this court's order while it was administratively stayed. So you don't get to say that we should have been working this whole time to do this, that, or whatever. It was stayed. That's what being stayed means. In light of the insufficient amount of time afforded to review the Supreme Court's order following the dissolution of the stay, Trump is not in a position where they can share any information that's requested at all. That is the reality. You're not getting it. Trump received the order late in the evening last night. We're reviewing the order. We're actively evaluating the next steps. It is unreasonable and impracticable for defendants to reveal potential steps before those steps are reviewed, agreed upon, and vetted. Foreign affairs cannot operate on judicial timelines, in part because it involves sensitive country-specific considerations that are wholly inappropriate for judicial review. So why don't you just take your little order and shove it, Judge? How about that? Signed, your friends. Actually, they didn't even sign it. Look. They didn't sign it. Oh, damn, son. They didn't sign it. That's great. Okay, so Yakov, Drew, Ernesto, and Tara DeShields. Shout out to you guys for being here and sending that one in. Just say, we're not even going to sign it, Judge. So you can come after all of us, right? No one's taking ownership of it, but they're all going to kind of join together and not sign it. It's like not going to sign that one. So enjoy it. You're not getting the files today, Judge. Sorry. Thanks for playing, though. Let's see what happened at the hearing. So we were waiting for this hearing because I knew it was going to be spicy. And let's see if Kyle Cheney was there. Said, here we go. So Kyle Cheney said this. Yeah, update. We've arrived at 11:30 with no responsive filing from the DOJ yet. Hearing set for 1. DOJ says it's not going to comply. Not happening. We just read it. Says the DOJ position says, well, I want information, not just the ones. So Judge Zinnis takes the bench. All rise. Oh, gosh. Says Zinnis begins by summing up the SCOTUS order, which she notes affirmed all aspects of my decisions and all my prior orders and save for requiring clarification. So saying this court amended its prior order and made clear what the government must do with the Supreme Court's directive. And that's what we've got so far. All right. So the hearing is like actively happening right now. Sure wish we could live stream it because that'd be great for America to be able to hear what's happening there. But let's see if anyone else is reporting on this right now. Let's see. Zinnis. That might be it for us on the day. The government filed their response. Let's see if anybody's reporting in. Okay. Kyle Chaney just posted this. Hearing is over. Judge Zinnis will require daily updates from the government on 3 things. Oh, gosh. What is his location and status? What efforts has it previously undertaken to get him back while her order was in effect? What efforts it may take going forward? Got it. Yeah, what efforts? So she's going to try to hold him in contempt too. She's micromanaging the executive branch. That was a quick hearing. Yeah, this is a good comment here from Nick. She can't do anything, such a joke. Yeah, it is. Okay, do we have more here? All right, here's more. I don't know why that thread didn't continue. So Kyle Chaney, thank you for reporting, says DOJ won't comply, saying Zinnis is now asking for an update on Abrego Garcia's current physical location and his custodial status. Where is he? What's going on? DOJ Drew Ensign says, Your Honor, well, we're still internally reviewing the Supreme Court's decision and we're vetting what we can even say to this court. Judge says, what? What do you mean? What can you say to me? This is a very direct question. Government says, well, Your Honor, it's not, maybe to you, but I don't even know where Abrego Garcia is. I haven't been told that. So I can't answer it because I don't know. It's national security. It's not my business. I'm just a lawyer. Zinnis is probably fuming mad. I can't believe this. We're here for a trial in my courtroom. I got out of bed on a Friday, dragged everybody in here. There's a man who's probably went nuts. Says this is basic information. I already ordered it to be provided, and you have to give it to me. And blah blah blah. Shout out to Drew. I don't have that information provided to me, Judge. Guess I'll just sit here. So then Zinnis is losing her bananas. Says Zinnis is now demanding details on what the administration has done to facilitate his release. What have you done? Well, what have you done? Did you try to do this? Well, I issued the order before the Supreme Court issued a stay. Did you guys start to remove him? Who said what to who's in charge? How'd the chain of command go? Blah, 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 all the thing. Your Honor, the defendants are not yet prepared to share that information. Shouldn't have had a hearing right now. If you're upset we don't have the information, you shouldn't have had a hearing. Oh, so that means that they've done nothing is what you're saying. Because if you're not giving me details, then I guess that means they've done nothing. And I'll just presume that. And I want a yes or no answer from you right now to whether the administration has done anything whatsoever to facilitate Abrego Garcia's release or return. Have they done anything at all? Drew says, Your Honor, I don't have any knowledge of that. I'm not familiar with the actions of what's happened, and I'm not familiar. Well, you do understand that you're sitting here in my courtroom, and the Supreme Court said that you should be prepared to provide info to me, but you haven't. And they've spoken quite clearly, and yet I can't get an answer out of you. Ensign says, well, Your Honor, the government we can't prepare and file something. We told you that on Tuesday. But we're going to assert privilege and we're going to assert, protections over our information. That's why we need time. And that's the deference that you owe us at the executive branch. Ensign says the government can be prepared to file something by Tuesday. Zinnis says, Tuesday? We're not going to slow walk this, says the judge. We're not relitigating what the Supreme Court has already put to bed. And they said, that, well, Your Honor, we read the Supreme Court's order differently. So, lawyers for Abrego Garcia now jump up. Your Honor, this is ridiculous. These Trump lawyers are playing games with you, depriving the DOJ of information. The court has ordered it from Trump. You have to give it to them and they have to give it to you. So you should demand testimony from all of the officials in the know. You should haul them in here and see what they know. He said, well, I might do that. But I think what I might do is a very quick briefing order. Yeah, because this judge is pathetic. She can't do anything. Very quick briefing order. Even the Supreme Court's trying to judge, calm down. What does facilitate mean? What does effectuate mean? Show them the deference that is owed. Because if you try to force them to do something, they just say no. A very quick briefing order. And they've got justification from it and cover from the Supreme Court. They're owed a deference. Now, Zinnis says she will demand daily updates from the government. we're not going to make a record of what, if anything, we're going to make a record of what, if anything, the government is doing, is not doing. And I'm going to rule as quickly as I can. So the hearing is over. Very short one. Kyle Chaney reported it. Want his location and status, efforts that have been previously undertaken, and what efforts it may take going forward. All right. So, of course, we will see what happens next, but that's the hearing. And so the Supreme Court issued a ruling, but is Trump going to bring back Abrego Garcia back to the United States of America? Do you think that's going to happen? Think he's going to put him on an airplane and send him back to America? I don't think so. So this judge is trying to create a contempt trap. And I don't think so far the Supreme Court has not wanted to jump in here and settle this. They could do that, but they're not. So as it stands, we might just be in this long game of updates and privilege and a battle back and forth. Whatever happens, we'll be here continuing to cover it. But we'll hope Trump and Kristi Noem and the DOJ continue their efforts to protect our country and afuera the terrorists. All right, so we'll keep our eye on that one. We've got one final update on the day, my friends, and then we're going to jump in and hear from you. Now, this one is a pretty wild story, and here is where we're getting going. Fanny Willis and her disgusting office are now taking advantage of and abusing a disabled man. You see him here in this photo. He was arrested, and his attorney is called Andrew Fleischman and has been pleading with Fanny's office to explain how this guy, who, as you can see, is in a wheelchair, is a paraplegic, his legs do not work, how he could be charged with the crime of kicking a door down and assaulting a woman. That's the allegation from a crazy person. He's now been charged with a crime. He's being abused. His attorney, Andrew Fleischman, is trying to call some attention to this for good reason. But Fanny, not when she's not sleeping with her special counsel, when she's not abusing disabled people, she's also out at NAACP conferences calling people who are attacking her scared little boys. And so we'll hear back more from Fanny. But here's this ridiculous scandal and travesty. Says Andrew Fleischman, he is an attorney. He works on behalf of the wrongfully and accused and unfairly convicted. And here's what he says. So my client is a paraplegic. All right. One day, a Fulton County Police Department officer asked him to come down and answer a few questions. A woman came into the police department and said he kicked her door down, kicked it, and assaulted her. And they were calling him down to arrest him, not to talk to him. Okay. He came down to the station. They arrested him. They said, sorry, sir, you can't kick down a door. That's illegal in this jurisdiction. So the client said, well, I actually didn't kick the door down, had some pretty good objections. He says, one reason I didn't kick the door down is because I'm a paraplegic, just so you know. So I'm actually literally physically incapable of even committing the crime, Fanny. So I can't kick anything. And also, I haven't seen this woman in 10 years. Are you crazy? And the police officer said, well, how did she pick you out of a lineup if she doesn't know you? Well, he said, she does. We dated a number of years ago. Now, I've been married for 10 years. So I haven't seen her in 10 years. And she said we just broke up. We didn't. We did not break up. I've been married for 10 years. They said, oh, yeah? Well, you're probably just a liar. You disabled person. He said, well, okay. When did this happen? This dude. Well, at this time. Oh, well, I couldn't have done it at that time because I was at a dinner party at the time of the incident. And there are multiple guests who are also at the dinner party who say that I was there with them. So I can't kick a door down. Cop said, well, it's not my job to investigate that, whether you were there or not. So the client says to his attorney, I'm pretty worried about this. If I go to Fulton County Jail, people are dying there like it's a disaster. Bed bugs, people being eaten alive in their jail cells. It's sick. While Fanny's cruising around the Bahamas. Says there's a good shot that I'm going to be badly hurt. I'm a paraplegic. So the jail is under DOJ investigation. There have been dozens of deaths there, like deaths, people dying in Fanny's jails. It's violent. It's poorly run. Sometimes the doors don't work. People are dying from bed bugs, being eaten by bugs. More than that, while this paraplegic dude is at the police station, they handcuff him. They put his hands behind his back in a wheelchair onto the ground. He falls forward out of his wheelchair onto the ground. He's hurt. No one helps him up, right? So they just let a disabled dude fall face first on the ground, hands behind his back, for kicking a door in. So for whatever reason, the police decide to let the client go. They say, all right, he kind of fell on his face. We'll let him go. But now he has this felony arrest warrant that's hanging over his head. Okay, so there's a warrant out there. Now, at any time, he could be taken down to Fulton County Jail for who knows how long, and there's an active warrant out. Absolutely ridiculous. So then he Googles the name of the woman who is accusing him, right? She's in the news. Oh, guess what? She's in the news. She's being charged with felony fraud for falsely saying that people have stolen things from her. Oh, or broken things at her home, and she files false insurance claims. So she's just a habitual liar. If you Google her name, it's the first hit. Cops didn't even do that. Here's what the lawyer did. He Googled her. It says, a Noonan woman has been arrested and charged after police investigated claims she was defrauding customers who stayed at her Airbnb. According to the police, the investigation started when a customer complained that a host was trying to charge him for a missing stereo equipment after he stayed there last summer. Police say the Airbnb host backed up her claim that the equipment was stolen with a police report she filed with the company. Only problem is the police report is fake. She never reported the incident to the police. She just gave it to Airbnb. So she's just a sick person. So then this lawyer gets in touch with the woman's parents, right? Now, this dude has a felony arrest warrant, has been in handcuffs, been down to Fanny's office, which just the smell alone is cruel and unusual punishment. So I get in touch with the woman's parents. They say, yeah, the woman is very mentally ill. Okay. She's not well. They say, oh, she's sick. Okay. Sorry to hear that. We're going to go see her. Family's going to come in. Now, when they see her, she confesses that she made the story up. Totally. No, that didn't happen. Never happened. They say, we're going to go down to the police station together. We're going to try to recant the story. Okay. We want to go down there and explain that she's crazy. Parents, the woman, everything. But no one will speak to them at Fanny's office. Look, dear Detective Gray, this case number from June 15, 2024 was filed on behalf of Officer M. Beloit. It has been brought to my attention that my mental state and physical trauma in that moment were to confuse me into providing information that needs to be edited. Will you please contact me at your convenience so I can edit the information in the report and clear the name of an innocent man? Okay, so this is the woman who's sending the letter. Hey, I was not well. I was in a hysterical mental breakdown. Okay, like I was lost. I've totally lost it. So let me edit the report and clear this dude's name. Okay. After weeks of calling, so this defense lawyer calls for weeks, an innocent dude. I finally managed to get in touch with someone at this police department. I lay out all the evidence. I say, I asked them to please dismiss the warrant. I've done this specifically. I have sat across from prosecutors, and one time I brought the iPad and I shoved it in his face. I said, look, I asked them to please dismiss the warrant because they won't answer emails. They won't answer phone calls. They don't give a crap at all. It's not their kids. It's not their life. It's not their liberty. They don't care. So I asked them to please dismiss the warrant. Can you please just get rid of it? This guy's an open warrant on him. I include an email from the woman that's recanting. Here's the response the defense attorney got back. Okay. Good morning. I would like to inform you that Officer Beloit does not wish to speak to you regarding this case. Okay. This matter will need to be handled through the courts. I recommend reaching out to the Fulton County DA's office for further assistance. Reach out to Fanny. Maybe they can help you. Okay. So these scumbag cops who have arrested and charged and harassed and abused an innocent disabled man say, contact Fanny if you want more. So in other words, they literally do not give a crap whether the client did it or not. My only recourse is to try to figure out anyone at Fulton County DA's office who might actually give a crap. Good luck. This is why I'm skeptical of government claims of guilt. That's why we all should be. Now, I'm posting this with client consent in the hope that with some media pickup, the College Park Police Department might reconsider its decision. Feel free to DM me if you want to write this up. Well, we didn't DM you, Andrew, but we're covering it. I have to point out that I have now seen the video of this woman describing the crime. She tells the police that he kicked in the door, was of average height, and then left on foot. Okay, the dude left on foot. So the paraplegic is kicking doors down and then doing handsprings and then racing around in a marathon on foot. This did not set off a single alarm bell for the dumb cops. Okay, he left on foot. She probably meant a wheelchair, though. So close enough. Foot, wheelchair, close enough. The officer is talking to his supervisor who says, well, the man is obviously paralyzed and could not have committed the crime. The supervisor says that. Officer says, he's obviously paralyzed, the supervisor, could not have committed the crime. Officer even says in the video, amazing, this is looking like a false report. Went forward with it anyways, yet they still went forward with it. Another supervisor confidently says, it's a ruse, man. It's an obvious attempt to not go to jail. So the other supervisor says, yeah, but he's effed up from the waist below. So cop goes back out. Well, I'd better get the lawyers on standby because I know he's going to make a big thing out of this. Explaining to my client that if she made a false report, that's on her, but he's going to have to take him in on a felony warrant after all of this. This dude, hey, man, sorry, I got to take you in. Says, I have to do my due diligence, I have to do my due diligence. These dumb cops who can't think for themselves. Whether you're innocent is going to be up to you and your courts and your lawyers. That's serve and protect in America. Good luck. Says the officer asked the client to prove that he's been paralyzed since 2001. Are you really paralyzed? Can you tap dance right now? Do the Irish jig. Get up right there. Let me see you do it. The client says, I can very easily show you that. All right. My driver's license has said it for 25 years. I can't walk. Officer goes back to the major who said the client was faking it. Client's faking it. He can walk. Major says, well, you can still punch someone, can't you? So you can still punch somebody. The officer says to his credit, well, I'm not sure he could do the forced entry. He's on wheels. It's like hard to break in. The major says, well, just call the DA's office, okay? Just call Fanny's office and say, can you rescind the warrant? Have them file something to rescind the warrant. The officer says, yeah, okay, that's fine. Goes down to Fanny's stinky office, but no one picks it up. Filled with noxious odor. Most people are probably gone. The major then says, but the warrant's never going to go away. So, yeah, this has turned into a delicate situation. So again, and by the way, like if you're even charged with a crime and acquitted and found innocent, you still will have a record of the charges, obviously. So these police officers are not convinced that the client is guilty, but they're too afraid to let the warrant go. Well, we can't, I don't know. He's not guilty. There's no point where they discuss even investigating it. Now, a thing I always tell the juries is that the presumption of innocence doesn't really exist anywhere. It's true. It doesn't, except when they are deliberating. Every other time we presume guilt. This is a depressing example. Now, if there's one bright spot, is the client successfully persuades the officer to have some mercy. Don't send us to jail. Okay. The cop didn't send him to jail after everything. Well, that's good. But if there's a lesson here, it's that police officers should feel like they have discretion not to bring charges. Because this was domestic violence, nobody felt like they could just drop the damn thing. He published the whole video. Wow. Says, here are some corrections. The client was actually handcuffed in the front, not the back, as far as I can tell, when he fell over. The officer really did have concerns over whether the client committed the crime. He just didn't want to rescind the warrant. And there was some discussion of further investigation, mainly calling the victim up to ask her to clarify, but she never picked up the warrant. So the warrant stayed in place. All right, so that is a disgusting story. Let's hear from Fanny Willis herself.
They picked the right day at the right time. And they are going to continue to be frustrated by the resistance. And the resistance is this. I plan to continue to follow my oath, and I don't really care how many times you threaten me. All right. You can keep investigating, targeting, but what is interesting is you choose two of the most powerful Democrats in the state to target. Why is that? It's because you're scared little boys. I hope somebody's recording.
Oh, scared little boys. I hope somebody's recording.
Yes, scared little boys who think they want a conversation with today. I'm telling you, get your popcorn that day. It's going to be a good day.
All right, so that's Fanny Willis. She's going to have a rough time. She is going to lose in the Supreme Court. She's going to have subpoenas delivered to her. She owes a bunch of money. And now she's arresting innocent disabled people and issuing warrants against them. So not real sure what's going on out there in Georgia, but wanted to shout out our friend Andrew Fleischman. Thank you, Andrew, for bringing this story to our attention. And if you want to follow Andrew and continue to spread the news about this, please go over there and repost that on X. All right, my friends. Well, we just had a great stream, and I want to thank you for being here and joining us. If you are just joining us, we covered a bunch of good stuff today. So starting out the show, we talked about how mandatory registration is now going to be in effect. So starting today, it is now the law that Trump's executive order is in effect, and people must register if you are an illegal alien. And the court said that the lawsuit that was intended to stop this is one that lacks standing and the claims fail. So some good stuff there. We went through some of the RussiaGate documents that were also published, courtesy of Sean Davis and our friends over at Just the News. Look through the binders. There were 7 of them in total, about almost 800 pages, I'd say, in totality between them. But we hit some of the highlights on what was inside the Crossfire Hurricane binder and really how corrupt the Democratic Party is, right? Spying on Trump's campaigns, trying to create a criminal narrative to steal an election, because that's all they have is theft and fraud, essentially. We also then talked about what came down out of the Supreme Court in the Judge Zinnis case and went through the hearing on that, which was scheduled today in an emergency fashion. So we saw that the Supreme Court really didn't give us much to go off of here. Just said, can you please clarify your order? Kind of kicked it back down. She's going to demand updates. She can't really force Trump to do anything. So we'll see what Trump does with this person. And whether they move him to a third country or bring him home or keep him in El Salvador, time will tell. But we talked about that. And then we talked about this horrific thing with Fanny's office and how she's abusing a paraplegic man who did literally nothing wrong. And he had to be put through the ringer, man. And this happens a lot in America, a lot more than people think. Cops just follow rules. They just follow. It's like paint by numbers. They just follow the thing. Hard to get them to do anything differently. So the prosecutor should be able to step in and do something about it, but it's Fanny land. It's noxious odor, every single room, door to door, stinkiness and corruption. So my friends, it has been a beautiful stream. Now it is time to hear from you, and we'll see what you have to say about all of this and more. Happy Friday! It's Papusa Friday, by the way, because Kilmar might be coming back to America, so we'll have a lot more Papusa soon. But let's see. Who is joining us on the day? And thank you, Carrie B. K. Bean for clipping for us, and Carrie B for clipping for us. You guys rock. All right, let's see who's here and joining us on the day. Thank you for sending these in. You guys rock. Hey, Jesser Bob said, I just wanted to share, look at this one. This is interesting. Just wanted to share my daughter's new globe. It's called Gulf of America. Is it? It is. Look at that. Look at that. Gulf of America, baby. See, that's what I'm saying. It's ours. We hug it from Texas all the way around into Florida. Look how much love that is. And it extends way further into the Atlantic than Cancun does. So it's ours. So amazing. Thank you for that. Shout out to your daughter. Gulf of America, baby. Beautiful sound. Look, there it is. It looks better too. It looks way better. All right, what's up? Hey, and AP is looking at this, having an aneurysm right now. What's up, B-Man? Says Letitia James declared Virginia as her main home. What? Is that new? I know she had the 2 homes. We talked a lot about that. Well, we did a video here, and then we talked with Stephen Gardner about that. I saw another video. Somebody was saying that she may have co-signed with her father as her husband, kind of a thing. Ugh. We'll look into it. What's up, Wes Downer? Hey, says, thank you for making Papusa safe. Save Papusa MS-13 members. Yeah. Well, America, we're going to have a lot more gangbanger Papusas. They're going to be wild papusas. They'll like come with like tattoos on them and fentanyl. Your papusas will have extra doses of fentanyl for you. So you'll either be dead or you'll be really enjoying your papusas, one or the other. Can't wait for it in America. Thank you, judges. Will Crump says, what good are documents if no one goes to prison? Well, the documents are good because they agitate us and raise our blood pressure, which actually is not that good for us. It makes us frustrated that nothing ever gets done. Yeah, they're not that good for much. We do want the documents with, like, I'd rather have charges than just information. But that's a pretty obvious one. Hey, what's up, Jonah Finn? What's up, Jonah Finn? Says, actually, my 8th, but not my tube. Nix them. It's your 8th month? Oh, man. Is that some sort of a plugin or something? Jonah Quinn, thanks for being a member. Thanks for supporting us. 8 months is amazing. One more month. We got a full baby in the house. Thank you, Jonah. Jonah Finn for that one. Yeah, fentanyl papusas. Yeah. More here. Bringing in 10 more here. Look at this. Thank you, more here, for bringing these people in. What's going on, Matt Man? Haima Decoys here. What's up, Ralph L? We got Lil Lass, Debbie Feaster. What's up, Kane? Big D's here. Leslie Long. What's up, Leslie Long? Wait, this isn't the Membo stream? No, this is the full stream. Your boy's traveling today, so this is our stream on the day. But Membos, we will be back tomorrow. We'll do a Membo stream tomorrow morning at the regular time. Preamble, what's up? And Zendow, what's up? Gifted a Membo. Great to see you. Hey, Cindy H, thank you for becoming a supporter, Cindy. Great to see you there. We'll see you tomorrow morning. .9 says, Bon Appetit recipe papusas. Are these the MS-13 papusas, though? I want the MS-13 papusa version with extra meth. Uncle Bozy says, if no Rogue Rulings Act passes the Senate and is signed into law, won't the same activist district court judges just rule it unconstitutional, drag it through the appeals court for years? Yeah, definitely. I also, yeah, but it's harder to challenge if it's a congressional law, right? Like a lot of these lawsuits are based around Trump's executive orders and Trump's proclamations. So if this is a new law that's passed, the lawsuits will have less teeth to them. So it'll be a little different. I also wonder if Amy Coney Barrett and John Roberts will side with the leftist SCOTUS justices to protect their turf. Yeah, maybe. But again, it's congressional statute, right? They're suing, like, they are suing under certain, like due process under the Alien Enemies Act. Certain things are old statutes that they're suing under, but a lot of these are suing his new executive orders. So when you have like 2 out of the 3 branches siding with something, so Congress passes both houses, then Trump signs it, that's like 2 out of the 3. Courts have a hard time overdoing that. Hey, what's up? Thank you, Uncle Bozy. Great comment. Sharpie guy. I saw where Trump is considering a carve out for the service industry who need these illegals for staffing. I saw posts about that, but I didn't see that from him or from anything official. So I don't know. I suppose someone got his ear about removing them to be politically bad for him. So is that official? Like, is that an official story? I had not seen it. Any question, Rob? Did Trump endorse Cornyn? I sure hope not. I don't know if he has, but it wouldn't surprise me if he did. And yeah, Ken Paxton is running against John Cornyn in Texas, which is good. What's up, Rick D? Hey, Rick. I had just literally finished reading Binder 1 as your show started. Some very interesting things in there, to be sure. Well, that's great, Rick. Yeah, there's a lot. I can't believe you read the whole thing. That's amazing. Yeah, and I wonder if you're seeing stuff, if you're posting about it, dropping that stuff on X, because it's kind of it's a group project. What's up? Hey, Def is here. Downer gifted some membos. Def got one. What's up, Player K? What's up, Beach Lover? Maggie got gifted membos, courtesy of Wes Downer. Thank you, Wes, for doing that. Amazing. This one from Just a Reflection says, I'm almost finished reading Cash's book. RussiaGate and the Steele dossier are a clown show, and the deep state is very real. Yeah, and they like to say like this is like foreign intelligence or whatever. It was Democrats. It was just the Democratic Party. That's all. That's all they were doing. All right, and where the heck did I just go to? Here we are. Thank you for that. Just a Reflection. Thank you for that. Ollie, what's up, Ollie? Bringing in Bella Beyond in the house. Welcome aboard, Bella. Great to see you. Don Marie, what's up, Don? Welcome aboard as a new supporter. Watch this. Amazing. Also joined up. Good to see you both. We'll see you tomorrow on the members only Saturday stream, and it'll be great. Uncle Bozy says, do you have to list FBI confidential source payments on your tax filings as income? Yeah, great question. Does the FBI just send out W-4s every year? I wonder what you put down as your profession. Informant, snitch, Democrat, hack, traitor to America? I don't know what you put on there. Good question. Jeffrey Adams, same question, basically. Did Halper or Steele pay taxes on the payment for information? IT is required by law to report it as income. $7 million is a lot of taxes and should have been repaid. Yeah, and like, is the IRS going to audit them? And if they got audited, wouldn't they just go to the FBI and just say, hey, if I get audited, they're going to see all this stuff, so don't get me audited. Like, are they on an exclusion list? Probably. So why would they report anything? Mars, what's up? Would Flynn, or they're foreigners, right? So they just probably routing it through Cayman Islands. Mars R, what's up? Would Flynn and Papadopoulos be able to have their cases overturned due to a violation of their rights? Well, so Flynn was pardoned, right? And I think Papadopoulos was too. So it's hard to do it in hindsight, right? So there's a provision in the law called petition for post-conviction relief. It's like if you discover things that happen badly after the fact, like let's say you're convicted of a crime, but it turns out the cop got busted for falsifying blood results or something, and that was directly related to you. You might be able to petition your case to get it reopened and thrown out, but generally not. Generally when there's a finding of guilt or a plea deal, it's very hard to undo those. Steel Manning. You're right. You're right. I blew it. Sometimes I drop the ball, my friends, and I apologize sincerely for this one. This is a big one. I feel like you overlooked a great opportunity. Trans de Aragua. Yeah, it's good. It's a good one. Trans de Aragua. Because yesterday we're like, why are these ACLU gangbangers like suing or representing all these gangbangers? And we learned it's because one has non-conforming gender identity. And that's why that person might be attacked in his home country or her home country or whatever. Trans de Aragua. Yeah. All right. What's up? Funny. Doan. Hey, download every episode of Dan Bongino through Trump's first term for the great scoops. Oh, from the first term. Yeah. No, Dan was also all over this, which is why we're excited that he's in there. Rick D says, Rob, you skipped over a very important part of Binder 1. Says Fiona Hill and Steele's wife went to college together, and Hill introduced Steele to his primary subsource, page 3 of the FD 302A. Amazing. Yeah, it's like one big happy family. They're all BFFs to take out Trump, but they're doing it in the interest of justice. Just a Reflection says, can't Tulsi declassify documents and remove redactions? You'd think so. I don't know why. She said she's in the process. She was on with Hannity last night. We played that clip. She said, we're working on it. Every time we look into something, we find something else. So I think she's just telling us to be patient. But yeah, I mean, she's the DNI. So that's a pretty big position. Leonard says, Dems are doing everything they can to disrupt Trump. Is this how Trump treated Brandon? No. And the Republicans didn't either. Like the Republicans, I think, sued some, Joe Biden about some, but not a lot. And the Democrats really control the infrastructure of the law. Like they control all the law schools. They control the bars. They control the ABA. They control all these entities. So they have the infrastructure set up for it. Hey, Jennifer says, Shane Souza says that Andrew Branca of Law of Self-Defense found a 2-page filing on this one. Amazing. Response to preliminary injunction filing is the title. Oh, I think we read that one. Yeah, amazing. I think we just read that one. Yeah, the one from Trump saying we're not complying, basically. So good luck. What's up, Bullwinkle Sprinkles? Thank you, Bullwinkles, for this nice dono. Says, DeSantis and the Florida legislature passed a similar alien registration law here. Canadian snowbirds are crying because they have to register and get fingerprinted. It'd be a lot easier if they were a state. They wouldn't have to do that. They're threatening to sell their homes and winter in Mexico. Oh, no. You're not going to have any snowbirds. We have a snowbird problem in Arizona, too. All these people come down here, don't know how to drive. It's ridiculous. Yeah, go to Mexico. Have fun down there. Thank you for the nice dono, Bullwinkles. They could become a state, or they can go to Mexico. Doan, what's Wheelchair Guy's settlement going to be? It's a good question. And a lot of the times Nothing. Okay. Most of the time, nothing. If you want the real answer, almost always $0. This happens every day in America. And cops just, nope, we got qualified immunity. We got a credible report. We investigated it. So probably nothing, to be honest. What's up, Diane AR? Good to see you. Thank you, Diane, for becoming a member. Can't wait to see you tomorrow. And D-Mail, good to see you too, D-Mail. Thank you for becoming a member. We'll see you tomorrow as well. It will be fun. Lays Maniac says, can every Friday be this fire? Yeah, there were some good stories today. That Fanny story, oh my gosh, it's horrific. So my friends, thank you for sending those in. Really generous of you. And I appreciate you supporting us on the show and on this incredible Friday. Let's say hello to our friends on X. Then we're going over to watchingthewatchers.locals.com. We will, of course, debrief over there and see who's joining us over there. Membos will, of course, be back on Saturday, tomorrow. What's up, FBI agent? FBI agent-elect Matt. That sounds good. It says, will you... Here, let me share this. Will you cover this on the tube for us? Should be a whole list of folks being charged with treason. Yeah, that's true. Thanks for what you do, brother, Newbie. Good to see you, FBI. Thank you, Newbie, for that. Yeah, I appreciate you saying that. I think we covered, hopefully, what you were talking about. Yeah, Gen X. Gateway Pundit says Tish named her residence as her primary residence in Virginia. Wild. What's up, Satellite Boy? Good to see you over there as well. And we appreciate our ex-friends. Diane just became a supporter over on the tubes. Great to see you, Diane. Glad to have you here. Awesome stuff. And my friends, I wanted to share with you this. So this is my mama's office. I kicked her out of here so we could live stream in here today. But I wanted to share a picture with you of my mama's mama, Grandmama G. Grandmama Govea in the house. It's my grandmama right here. So I found that photo. Just wanted to share with you my beautiful grandmama. Rest in peace, Grandma. She's up there, but got some great photos in here of the family. And so that was on the desk. Wanted to share that with you. We love our grandmas here, don't we? All right. So my friends, we're going to leave it here on the day. We're going over to locals, watchingthewatchers.locals.com. We're going to hang out and debrief over there. Members, we're going to come back on Saturday. And of course, get into it again tomorrow. But thank you for joining us early. As I mentioned yesterday, your boys traveling around yesterday. We had a great, where's my phone at? I don't know what I did with it, but we had a great birthday celebration with my friend Dick. He turned 80 years old yesterday. We had a bunch of people there, had a very happy birthday, had Chinese food, had cake, and it was a lot of fun. So happy birthday to Dick. Also going to be meeting up with some friends who had a brand new baby in the house. And we're excited for them too. So thanks for understanding the travel schedule. Thanks for accommodating and joining us live. I really appreciate you being here and going through these stories with us. It's always a ton of fun and a real honor and a treat. What's up? Hey, Object Class Keeter just sent this one in as we wrap it up. Who remembers the guy who super chatted that this channel will have a hard time finding stories for episodes? I think it's safe to say that that's wrong. Oh, yeah, I got a lot of that after the election. Stephen Ayers, what's up? Thanks for becoming a supporter. I got a lot of that, both offline and online. People saying, what are you going to talk about now? Even in person. Like, isn't your show like over? Because like all you would do is complain about Biden. It's like, ugh, are you crazy? We're just warming up, baby. We're taking over now. We got the ball. It's offense time. So we're just getting started here, my friends. Thanks for that, Object Class Keeter. Yeah, because Trump won, right? A lot of that. This channel is not about Trump. This channel is not about Biden. This channel is about accountability, transparency, and justice. That's what we stand for. That's what we cover. That's what we want for our lives. That's what we want for America. So as long as those are important issues, we're going to be here fighting for them. And we appreciate you joining us as we do. So my friends, we'll pause there. We will head over to locals. It's been a beautiful week. Thanks for being here. Thanks for being awesome and for having so much fun with us. I want to wish you the best weekend you can possibly imagine. I hope that you're doing something fun, something exciting, spending time with friends, family, the people that you love, getting outside, getting some fresh air, getting some vitamin D or whatever, just hanging out on the couch, soaking it up because you deserve the rest and the restoration. We're going to come back on Monday. We're going to get into it again before we round it out on the week. We want to thank our amazing mods and meme smiths who mod the fork down for us and keep things nice and orderly around here. KB in the house, donut mind me. We got Carrie B playing hooky, Dog Digger, Janek, Geegum, Geegum, Just Rhonda, and Elliot, our Doc Master, purveyor of fine emojis, and Meme Smith, all helping out. My friends, that's where we're going to leave it on the night. I want to wish you the most beautiful weekend you can possibly imagine and remind you that we're coming back here on Monday next week to get into it again. We'll be back home, and we're going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful weekend, my friends. I'll see you right back here on Monday. Bye-bye.